Okay, welcome back from lunch. We're going to get started now. So the panel we have now the purpose of the panel we have now is to discuss the policy environment for intellectual property. In keeping with our common theme, we have representatives from both the creative industries and innovation industries to talk about the current policy climate for intellectual property, challenges they face, and where they see policy, IP policy going. I'll briefly introduce our panelists. On my right is Sandra Astars. She's the Chief Executive Officer of the Copyright Alliance. Lori Self, Vice President and Counsel for Government Affairs for Qualcomm. Phyllis Turner-Brim, Vice President, Chief IP Counsel of Intellectual Ventures. And Matthew Rainey, Director of the Innovation Division of the World Intellectual Property Organization. We're fortunate to have this panel with us. As Adam suggested earlier, you can look and you can search and find their distinguished biographies on their own, and I assure you they are indeed distinguished and most important, they're experienced and effective policy professionals, and so we're fortunate to hear from them. What we're going to do is a little different from what we're doing with the rest of the conference. There aren't formal set presentations. I'll be asking them a series of questions about the policy environment, hoping to get some dialogue going among them as well. And I encourage the audience to consider what your interests and questions looking ahead. Now, in many ways, these two industries face different policy challenges, and yet some of them are the same at a high level, I guess keeping with what Richard Epstein encouraged us to do. Oddly enough, I think they have many of the same opponents, spending quite a bit of money to stymie their ability to exercise and protect their intellectual property rights. But more important, they also face a changing climate for intellectual property in Washington. And so along those lines, let me begin with my first question. It seems like the ground has shifted in recent years regarding the perception of the value of intellectual property protection. From rhetoric vilifying big copyright to claims about so-called patent trolls, the climate for those who own and assert intellectual property has become less friendly in Washington. Why has this happened, and what can be done to fix it? Sandra?
So I guess I'll do a poor imitation of our lunchtime speaker and start by quibbling a little bit with you at your framing of the question, and say that things maybe haven't changed as much as we might think. I'll agree with you that the rhetoric may have become a little bit more heated or a bit more amplified around these issues in recent years, but I think that sadly that might be true of discourse around all political and social topics, and it may be more a result, or at least partially a result, of sort of the fast-paced and maybe poorly thought out way we respond to questions, and may be motivated also by some of the communications tools that we use that are often anonymous and allow us to express ourselves in ways that we might not otherwise express ourselves in common discourse. I think if you look back at the debates that were occurring at the last time that Congress was taking a look at the Copyright Act as thoroughly as it is looking at the Copyright Act now, the sorts of arguments that were being made against having strong copyright protections were surprisingly virtually the same as the ones that are being raised today. The same sorts of arguments were being made at that time, by cable companies and photocopying manufacturers as are being made today against industries who folks claim need to find new business models or are claiming that existing industries are full of entrenched interests and are backwards thinking and so forth, and that IP protections are somehow harming the ability to innovate in other industries. And to be fair, I think also on the pro-copyright side, the arguments have also been quite similar over time in favor of copyright, the importance of protecting jobs, protecting the economy, protecting innovation in the creative sector, the constitutional origins of intellectual property rights, the fundamental fairness issues involved. So happily, regardless of the fact that there's not been a lot of innovation in our rhetoric, I think there's been a lot of innovation both in the tech sector and in the creative communities, regardless of the fact that we haven't been all that innovative in our rhetoric over time. And so I guess I can live with the fact that we're not innovative in our rhetoric as long as our laws are staying properly calibrated and are motivating the creation and dissemination of creative works, and also the creation and innovation in the tech sector to bring us new ways of distributing those creative works. The one thing that I think has truly changed and is something that we should all be worried about is that, different from 40 years ago, where I think that debates were occurring really between legitimate businesses on both sides, disruptive forces, seeking to move aside, maybe move forward in different ways than the existing industries had been moving forward. I think now there is an additional element to some of these arguments that we're hearing against intellectual property protection, and an element that goes a little bit further than what we've heard before and almost seeks the entire elimination of intellectual property protection. And that element, I think, is coming, if in its most aggressive form, not from any sort of innovative sector in any business, but is coming more from the I'll call them criminal elements, cyber lockers, entities like that, who supports and benefit from cyber lockers. And they are not interested in intellectual property in any way. And I think those of us who rely on intellectual property to, in our business lives, are just collateral damage. What these entities are interested in is to use our works as a lure to get eyeballs to their sites, and they're not interested in what they're using as a lure. They're interested in what data they'll be able to gather on one end, and that's the least nefarious issue. More troubling are the sort of privacy violations, the fraud, the malware, the other scams that are perpetrated by these sites. And so I think that's the issue that we need to worry about fixing if we're worrying about fixing anything.
Okay, thanks. Lori, what do you think about the climate for IP rights?
So I will agree with Sandra in part, and then I'll maybe disagree in part as well, and focusing more on the patent space and the copyright space, although again, I think the trends you see in one area of IP very much repeat in different areas. But historically, I know there have been a number of academics, including Adam, as well as Zarina Khan and others, who have taken a historical look of trends in the patent system throughout the history of our country. And so these very heated, emotional debates about the benefits of patents are in fact nothing new. And again, if you go back to newspapers in the late 19th century during the so-called telephone wars and the sewing machine wars, and there was a tremendous amount of heated rhetoric about patents and efforts to weaken the patent system. So I guess in a sense that's not new. But when I look at these issues throughout my career, which around 25 years or so, I do feel like we're in a period of change. Again, maybe it's not new, but there is a change in how intellectual property is viewed in this country today versus, let's say, 15 years ago. For the first decade, if not longer, of my career, the U.S. was very much at the forefront of advocating the importance of strong intellectual property worldwide. We were the standard bearer. I mean, there was this sort of, I think, unity of view that intellectual property was worth protecting. There might be disagreements around the margins, but now I feel that we really have entered kind of a different period where the anti-patent sentiment has become so pervasive, and again, that's not accidental. I mean, you can trace some of this to corporate dollars, corporate interests that are very aggressively energizing different voices on these issues, very aggressively energizing the media, very aggressively energizing regulators, politicians. So it's not, this is not organic, I guess I should say, but it is disconcerting. Why we see this happening, I think, again, if you look at the roots or the origins of different periods of heated patent debates historically, fundamentally it comes down to a clash of business models. You have companies like ours who are heavily dependent on patents to incentivize investments in research and development. We're heavily dependent on patent licensing revenue to generate dollars to continue that investment in R&D. Obviously, there are other very significant corporate players that are predominantly users of third-party patented technologies, technology aggregators. We now see with some of the Silicon Valley-based companies new business models, which are really fundamentally dependent on this notion of ubiquity. I mean, I think one of our previous speakers talked about ubiquity as not being necessarily a good thing for creators or innovators. It's definitely a good thing if your business model is data aggregation. You want ubiquity because the more users you have, the more data you're generating, the more ad dollars you're generating. That's fundamentally a different business model. Now, my very strong view is that policymakers should not be choosing one business model over another as long as they're legitimate business models. And again, going back to Sandra's point about the criminal element being sort of now kind of an important third-party player. But in terms of legitimate business models, our policies should incentivize both. So this notion that we should be weakening patent protection to bolster Silicon Valley, to me, it's completely wrong-headed, and it's just bad policy, no matter how you look at it. But there does seem to be this sort of notion within Capitol Hill and more broadly that the true innovators are in Silicon Valley, and since they're saying that patents are no longer important to innovation, therefore we need to weaken patent protection. So again, fundamentally a clash of economic interests, a clash of business models. Again, I think one of the things that's very different today than when I was in my earlier parts of my career, the fact that patents have entered the popular narrative. The fact that you hear, Google patents and you come up with, hundreds of blogs and media reports, and the fact that it's now part of the common parlance, and again, that parlance is largely negative, I think is definitely a shift. And again, I don't think it's organic. I think it's part of a fairly well-orchestrated campaign, but it has really complicated the ability in Capitol Hill to pursue rational policies. And one of the concerns I have is the speed with which really sweeping changes to our patent system are being pushed through Congress. We saw that in the House in late 2013 when a bill, far more comprehensive in scope than the American Invents Act, literally raced through the House in, I'm not even sure how many days, maybe a little over a month. Virtually no member of the House understood the impact of that bill. They were voting because they were being led to believe that this was legislation that was necessary to eliminate abusive litigation, to eliminate so-called trolls. Historically, there has been a much more rational, deliberative discussion around changes to our patent policy. We saw that during the AIA. Certainly there were political forces that were trying to rush through a bill, but at the end of the day, it was a 6 or 7 year process. What we're seeing now is an effort to ram through legislation at the equivalent of lightning speed. And in part, that's being driven by economic corporate interests. It's also being driven, though, I think, by a Congress that's just desperate to show that it can get something done. It can't get immigration reform done. It can't get tax reform done. It can't get a variety of other things done. this feels like something that it can get done. And I really worry about pushing through legislation that could have really profound economic consequences in this country with so little appreciation for the impact on our innovative community, particularly smaller inventors who, potentially could be crushed by some of the proposals that are being put forward. So I think the political process has changed, the rhetoric has changed, the amplification of that rhetoric has really changed, and just sort of the general institutional respect for IP in this country, I think, has shifted. The most pronounced voices on IP policy today within our government are antitrust regulators. I view that as a challenging aspect of the debate. So again, if you look historically, you could point to different parts of our history where maybe there have been similar frictions in the system, similar heated debates, but at least over the last quarter century, this feels like a very difficult time now for those of us who care about intellectual property.
Thank you. Phyllis?
On now? Okay. Well, certainly agree with the comments that have been made by both Sandra and Lori. I think one of these debates are not new, as Lori has mentioned, that in every really strong technological innovation mode and node that we've had in this country, there have been these so-called patent wars that crop up around that. But also, as Lori mentioned now, there seems to be this drumbeat of attack on not only patents, but also certain types of patent owners and certain types of business models. And a lot of this has been driven by anecdotal information that's not necessarily data-based. And there are lots of great things that can come out in sound bites and, in our case, NPR stories. And lots of rhetoric around patents killing innovation. Well, the Patent Office, according to all reports, is busier than it's ever been. If patent filings and patent issuance are any sort of indicator of innovation, then we're doing quite well in this country and worldwide. So there's a perceived issue concerning the litigation that is being pursued by so-called non-practicing entities. But again, a lot of interests who are putting forth that there's this big NPE problem have a direct monetary interest in there being an NPE problem. And when you look at truly objective data, like from the PricewaterhouseCoopers study, the GAO, and also a paper that was co-authored by one of our speakers this morning, Jay Kassan, with regard to who is really suing on patents. It's operating companies suing operating companies for the most part, right? About 20% of patent litigation over the last several years has been filed by NPEs. So we have all this flurry of emergency and all this flurry of activity that is based on anecdotes and not data. So one of the things that I am encouraged by is that we have conferences like this where people are talking about data and are talking about how we can gather data, how we can do studies that actually bring forth the true information around this, that the house is not burning down. And in fact, protection of intellectual property is one of the key attributes that's the economic engine of certainly this country. So politicians, unfortunately, frequently only have time, I'll be very gracious, only have time for the soundbite. So it is incumbent on folks like us who have data, who have information, to be out advancing sort of the thought that we should be thoughtful and surgical in modifying our intellectual property laws. And I'll just say this, the AIA is new, it's a baby, in a lot of ways. And like a baby, it's growing and creating a little havoc, and we quite haven't figured out how to manage it. And so going into another round of comprehensive patent reform without really letting the dust settle around patent reform, which was a major overhaul that just occurred, will lead to a lot of unintended consequences. And my view is that the folks that will be ground in the gears will be the small inventors and will be the small startups who won't be able to leverage value for their inventions and innovations.
Thank you. Matthew?
Am I on the air? Is this mic open?
Yes.
I might like to take it in a little bit different direction. Let me pick up on Phyllis's last phrase, unintended consequences. I used to work for Phyllis's company. Well, it's not really your company, but I used to work for that company. And I worked on this very act for 6 years of my life, and went through hundreds of thousands of words. And I used the phrase unintended consequences. I used to keep arguing on the Hill, this is going to have unintended consequences, and then I changed it. It has intended consequences. It's not an accident. But I'd like to take it a little bit different direction, because we understand that some people will be better off practicing their products without paying licenses on the patent owner's patents. We understand that. But it's in a sense more complicated than that. So I'm a patent lawyer. I've worked in companies mostly and in law firms, but the companies I've worked for have owned patents mostly, and I've licensed them, and we've enforced them and so on. I've also worked for law firms where we've been on the receiving end primarily, so I've also been on the defendant side of things. And I don't see it, I see it as a complex sort of web. For one thing, on the defendant side, when you are faced with somebody asking for a license fee, there are several big problems right away. They may believe you have a valid patent, but there's a credibility gap to begin with. There's a mistrust in the quality of the patents, which is very well placed in a lot of cases, not in all, but many. Especially in the software industry, there's a lack of, for at least many years, there's a lack of any kind of database to do prior art searches. And having written probably thousands of software claims, I can say that most of the software claims I see out there in patents that I come across are of, by definition, average quality, and the average quality isn't very good. And so while Qualcomm's and Intellectual Ventures patents are all perfect and have no problems at all, and of course that's not the case with anybody's portfolio, but I know how it goes at IV, and we were very careful to vet our claims very carefully. We would get rid of them if they weren't very good, and would reissue them if they needed to be reissued. But most patents are not taken care of in very great detail. And so you see patents being asserted where the nuisance value ends up controlling rather than the quality and the coverage of the patents. And that's very, to put it mildly, annoying. Then there's the expensive enforcement. If you're a small patent owner, you can be held up by the infringer quite easily because you can't afford to go through enforcement. And it's different for different industries. In the pharma industry, I'm not in the pharma industry, I never have been. My background is sort of physics and computers. But my impression is that even though some claims are certainly invalidated, there's a sort of stronger sense of the validity of those claims. For one thing, they're tied to real products that are doing real things for, sick people, for instance. In the software industry, it's the other end of the spectrum. People very often don't believe in them. You have phrases like software wants to be free and software is speech and all this kind of argument. And you have, can I get anecdotal here? My first engineers meeting when I worked for Sun Microsystems in 1994 was with the Sun Labs, and it was 50 software engineers. And I started to, coach them on how they could capture their, do their invention harvesting and so on. And I was immediately blasted with, why the hell are we patenting software? And I spent the rest of the time with my back against the wall. I came out a bit bloodied but unbowed. And that's the way the thinking was at Sun Microsystems, a big IP owner on the rise up. And even in-house we had that debate. It was a very good debate to have. And so I think we need to, to take a third example of an industry, semiconductor industry, it's much more the norm when Texas Instrument gets a patent issued for the others to come knocking at the door saying, we'd like to cross-license with you, we like what you got, let's do this. And they do that. It's very odd from the software industry point of view to see that behavior. But I think what we need to do is get rid of some of the fundamental problems, like the credibility of quality. The America Invents Act was supposed to solve a lot of this, but it added a lot of process, which, days are early, but I doubt that it's going to really solve that problem. We still don't have very reliable searches at this patent office or any other patent office. Databases have gotten better. They're certainly a lot better than they were 10 years ago. But software prior art is not readily accessible. There's stuff that's 20 years old that you will never find on a database. In the AIA, there's a provision for submitting prior art. One of the things I argued for years to these House and Senate members and their staffs was that when you submit prior art to the patent office, you should be required to associate claim elements with products in the prior art you're submitting, or you're wasting the examiner's time. You're just submitting stuff, gets a big stack like this, and he doesn't really know how to associate. Do the work. We should have required that, and I think that's something we could still do, and that would help. We can set up a situation where you can submit prior art and knock out a lot of bad patents because you've really associated it with something that shows that those elements existed in the prior art. And Qualcomm and IV will be thankful for this, because you know why? You won't litigate those patents, and I know you don't want to. And you don't want to litigate a bad patent. It doesn't do anybody any good. So tell me which one the bad ones are, we'll get rid of those. So we need to solve the credibility gap of the honest people who are out there, not just infringing, but really trying to make products and get through with freedom to operate. And believe in the patent system, because when I come to you for a license and I say, I think you need to license, claims 1 and 5, I don't want to have the argument every single time, and this is why you can believe in my patent. Yes, there's a good search. Yes, it was issued properly, and so on. Let's take those issues off the table. It's a very complicated set of issues, but that's why I think that's what I think part of this problem is. Part of it is what the ladies here have said, that there are people out there who just want to practice without paying. But part of it is that there's some complicated issues we have to deal with.
Okay, so let's change things up a bit and talk about the relationship between creativity and technology in the creative industries and the innovation industries. So there's this conventional wisdom that says the two are always at odds. It frames things in terms of debates between Hollywood and Silicon Valley, which I think probably leaves a lot of people out. And this conference attempts to challenge that conventional wisdom. So what do you see as the common ground shared by IP owners, the common needs and challenges? Sandra?
So the common ground, I guess, summarize it in one word, it's innovation. More and more creators are playing dual roles, both as authors of creative works and as either tech innovators who themselves develop or who adopt or drive the adoption of new technologies for the distribution of their works. And so when you look at what's happening in the creative community, you see that more and more the creative community is becoming indistinguishable in some ways from what you would have classically thought of as more the engineering-based tech community. Some of our members at the Copyright Alliance, some of our supporters, include the Software Alliance and the entertainment software industry, gaming companies. These are copyright owners who are themselves really tech companies. So it's very hard to sometimes even distinguish, what's a copyright owner, what's a tech company. I think when you think about how the creative community interacts with the tech community, the innovation community, I think the creative community can be viewed as a major source of innovative ideas. They offer services sometimes which themselves can be inputs to innovation in other fields, and they're also intensive users of technology and drive, therefore, new developments in technology fields. So I think we have common goals, and we reinforce each other and support each other very frequently. If you look at what has been happening in the creative community, it happens all up and down the food chain, if you will. We're looking at the size of creators and innovators. I mean, you can look at people who are as well known as James Cameron, who is famous for driving a lot of innovation in 3D technology, camera design, motion capture technology when he made his film Avatar. But at the same time, we're working with grassroots filmmakers in our network. Trisha Ziff is a good example. She's a documentary filmmaker who was working using social media tools and other means of communicating remotely to produce and direct a film, collaborating also with a number of cab drivers in Kerala who are helping her shoot portions of her story there when she was not able to be there. There are various new distribution platforms that have been developed collaboratively between the entertainment community and the technology community. I've had the pleasure in my previous career of being involved in the development of several of those, including the DVD platform and the Blu-ray platform and the technologies that supported secure distribution of motion pictures on those platforms. And those involved both a great interest in driving businesses in the copyright industry forward, and also an interest in driving businesses in the patent protected industries forward, and great cross collaboration between the CE industry, the IT industry, and in this case the motion picture industry, both to develop the underlying technology formats and also the technologies that would apply to protect the creative content that was being distributed and licensed. And this is happening in other fields as well. The New England Journal of Medicine is a very good example. They've got a very broad group of medical illustrators, and they've developed technology that allows them to do 3D video animation of the images that they present, and allow their readers to manipulate the images on an axis so that they can see different perspectives of those images. That is benefiting people not just in the creative community or the research and science community who are doing the copyrightable writing of articles in the journal and the publishing of the journal, but certainly benefiting the researchers who are relying on that technology to be able to understand better the images that they're interacting with and use them to drive forward their own research and their own scientific, medical, biochemical research that they may be conducting. I think our needs and challenges are common in many instances as well. If you look at what's happening in the creative sector and in the innovative sector, I think all of us need some degree of creative freedom to be able to prosper in our chosen lines of work, and that implies both the ability to create free from undue outside influence in the way that we express ourselves, but also the flexibility to set the path of your creation once you've created it, and to ensure that you have the ability to get a return on the investment that you've made in creating that work, whether the work is a copyright protected work of authorship or a patent protected invention. I think the similar challenges that we face in the copyright world, whether as small businesses or individual creators who are faced with the difficulty of enforcing claims in federal courts and not having the ability to ensure that the damages awards that we would ever get back for the sorts of claims that we're bringing would ever even come close to the costs that need to be invested in bringing a federal lawsuit, are quite similar to the sort of challenges that small inventors may face. And on the other side of the spectrum, the enforcement challenges are equally daunting when you're a corporate copyright owner and making multi-million, hundreds of millions of dollars of investment in your copyright protected works, employing thousands upon thousands of people at your studio, or employing people within a community to support the creation of a film, say, and then not being able to adequately enforce its distribution through authorized channels and monetize that appropriately, free from interference from outside sources. And it's not important just to us and to us in the creative community and in the technology community. It's important to all of us as citizens, as members of the US economy. And it's, I think, important to the global economy. WIPO did a study in which it analyzed 30 national studies of the contributions of copyright to the economies of various countries, and they found that there was a very strong and positive relationship between the contributions that the copyright industry made to the gross domestic product of these countries and economic freedom in those countries, as well as their global competitiveness, their ranking in terms of global innovation scales, and their ability to engage in R&D. So this demonstrates not only the tech and copyright interests are aligned in any given economy, in any given sector, but that those interests taken together are beneficial to the entire population of any given country.
Thank you. Lori?
Okay, so just to build on a few of the points that Sandra made, and maybe to build on some of the points that Professor Epstein and others made this morning. I mean, certainly we share an intellectual property clause in the Constitution, so there is a very clear common legal, moral, economic foundation for both copyright law and patent law. And fundamentally, the vision was that if you allowed individuals to benefit from their creative output or their innovative discoveries through enforceable property rights backed by meaningful remedies, governed by contracts that were rooted in freedom of contract principles, you would actually create the sort of fertile ground, if you will, for economic opportunity, wealth generation, et cetera. And we saw the remarkable success of that vision in the first 100 years of this country's history. So I think it's always important to look at the historical roots of these two forms of property rights. And then, again, building upon some of the comments that Professor Epstein and others made, clearly we need, if we're we're going to incentivize small inventors or large inventors to make high-risk investments in technological development or creative development, there needs to be some foundation of property rights to create those incentives. There needs to be some meaningful opportunity for a reward, a return on those investments. And so, you know, I think that's true of creative industries. It's true of so-called technological industries. And I will, Mark, just to not take issue, but just to comment on your original question. I think sometimes there's a perception that tech is monolithic in its perspective on intellectual property. You know, Qualcomm views itself as part of our technology ecosystem, and obviously we are a strong believer in the promise and benefits of our intellectual property system. So just to sort of make that point, that again, I think if you look at different business models within the tech sector, you kind of better understand why there might be this perceived clash between so-called innovative industries and creative industries. I think, you know, the reality is that when you're talking about individual artists, individual inventors, private capital investors in those sectors, companies like ours that continue to make huge investments in R&D, that dynamic cannot survive without an intellectual property system, copyright patents, that's rooted in a foundation of property rights. So again, I think there's a common economic rationale and purpose of our intellectual property rights, regardless of whether we're talking about copyright or patent. And again, just to point out the interest of independent inventors, small inventors, artists, et cetera, versus, you know, large dominant manufacturers. I think, again, one of the historical purposes of having an intellectual property system is to incentivize the little guy, is to provide the little guy or the little or the woman with an opportunity to participate in new markets, to make investments in disruptive innovations or new forms of creative expression. And I think our patent system, our copyright system really is and should be very laser focused on the needs of the smaller players. Qualcomm will survive no matter what Congress does to our laws. That's not true for independent inventors, startups, smaller artists. So it's really that part of the innovation ecosystem that we really need to listen to focus on when we think about potentially fundamental changes to our system of copyright or patents. And again, I think that is very much a common concern, a common focal point for both systems of intellectual property. I'll also say, I know there's been some discussion of trade secrets, and there's a lot of focus on trade secrets today, and trade secrets are incredibly important, but when you think about what drives innovation in a modern economy, and again, maybe this was true 200 years ago as well, it's collaboration across industries, across geographic divides, across technological platforms. Trade secrets are far less suited to that form of collaboration than patents or copyrights. Patents are about disclosure. There's a quid pro quo. I will disclose the best mode of my invention to you if, in return, I receive these exclusive rights. If in return there is this promise of a monetary reward on my investment. You know, trade secrets are about building silos, vertical silos. That is really, not to say that there isn't an appropriate role for that, but it's far less of a facilitator of the kind of collaboration this complex economy critically depends upon. You know, Richard, in his remarks, was talking about the supply chain networks, these incredibly complicated networks that all large players in the creative industries and technological industries depend upon. Again, those networks benefit from strong copyright patent rights that are rooted in the fundamentals of property law. And then going back to a point that Sandra made, and then I think also Professor Epstein made, we also want a legal foundation that does promote voluntary relationships, voluntary collaboration versus coercive intervention by regulatory authorities or government authorities. Again, I think that is a common truism for both of our systems of intellectual property, for both industry sectors that are dependent on the different forms of intellectual property. And again, going back to the concerns about what we're seeing now in the regulatory and policy landscape, we're seeing a much more concerted push towards what I consider to be very aggressive intervention by regulatory authorities, constraints on licensing negotiations, constraints on valuation of intellectual property that are really being dictated by regulatory norms versus market principles. That is really disconcerting because it is antithetical to the fundamental drivers of strong innovation, property rights, freedom to contract, rules that promote voluntary collaboration. And so I worry that dynamic could really undermine the foundation of both our copyright system and our patent system. And then finally, again, to build on one of the points that Richard made in his remarks, I really wish our policymakers, whether we're talking about at the agency level or in Congress, understood the role of injunctions, understood the dynamic between injunctions and damages in the way that Richard explained them. For those of us who have lived and breathed in innovative industries throughout our careers, I think we all understand that an injunction creates incentives. It creates incentives to come to the table voluntarily versus forcing the owner of a property right or an intellectual property right to go to court. For companies like Qualcomm, where we license our patents on a portfolio basis, there is never going to be a situation where we receive damages that are commensurate to compensate us for infringement. And that's in part because you can never litigate a full portfolio, but it's in part because whenever you're forced to go to court, you disrupt an ecosystem, not only of your supply network, but of your licensees. So this notion that somehow injunctive relief is unnecessary or anti-competitive fundamentally misunderstands the role of remedies in providing the foundation for these property rights that are so critical to create the kind of economic incentives we need to continue investing in our innovation and creative industries.
Thanks. Phyllis.
Well, to pick up on the incentive point that Lori was making, we do in both the creative industries, and actually I think that's interesting because in my view, the innovation is just a just results from creativity. So one of the things that these industries have in common is that they're rooted in creativity. And how those come into existence are in different veins, but the reality is, as Sandra was mentioning, and for years this has been the case, even in what we would consider to be old school manufacturing companies that have products, that the protections around those products encompasses all aspects of intellectual property. Copyright for the marketing material or the code or other things, trademark, patents, trade secrets for certain manufacturing aspects. So any weakening of any protection in any silo or in any area weakens the protection overall for everyone. So the attack on IP rights is really overall an attack on business, and people should view it that way. Because even those companies who are the loudest, and those players who are the loudest about how there's such a problem and that certain types of intellectual property shouldn't be protected with patent or shouldn't be protected with copyright and various other things, are leveraging those protections in their businesses and will continue to do so. So the incentives to collaborate, the incentives to reach agreement are critical. And what has happened is that those incentives have gone away in a lot of ways. Right? So why is there more NPE litigation, if that's what you believe? It's not because NPEs have changed. It's because the legal framework in which they operate has changed. So there's no incentive to reach agreement before we go to a lawsuit, right? Because there's no leverage that the patent owner would have in those circumstances. So as long as entrenched players can just view patent infringement as sort of the cost of doing business, that's how this will operate. And as long as they don't have incentives to come and reach resolutions with patent owners, which is critical, we will continue to see a lot of litigation of various kinds in this space. So I think that's something we also have in common in terms of copyright.
Matthew.
The problem with following three smart people is they may have left nothing to say. There might be a little white space here, though, and I didn't run out of things. I'd like to sort of start with a premise and continue with a couple of quibbles. The premise is that I take it for given that protection of intellectual property should be rewarded in some fashion. It's provided in the Constitution. We had a very good opening talk today describing the whole philosophy behind that. So those who think that there are certain kinds of innovation that should not be protected or should be free for the public, I'm not going to argue with that or make that point that was made this morning. One of the quibbles I have is that innovation and creativity are by no means mutually exclusive, and actually Phyllis more or less just said the same thing. If you have innovation, so-called innovation that's not creative, how can it really be innovation? That can be just a semantic argument, so I don't want to dwell upon it. But the point is that there's a commonality, and that's what Phyllis just described. And the commonality is something new, is something that contributes a combination or a thing that wasn't there before, and we want to reward that. The other quibble is, Mark, this isn't fair, but I'm going to go back to your talk this morning. When you were talking about the definition of property, and I doubt that you intended that to be an exhaustive discourse on the philosophy of property, but you talked about the right to use, and I really emphasize the right to exclude. So property, if you define property as the right to exclude, the point of view, and I say it's a quibble because I know you probably have some response and you're welcome to say it, but I just wanted to use it as a vehicle to get to my point. It's important because when you think about licensing your innovations or your creations, you aren't giving somebody the right to, for instance, play your song or use your invention. You're giving them the agreement that you're not going to sue them based upon your right. It doesn't give them an affirmative right at all. You may have infringed somebody else's song, and they still aren't free to do it. You may infringe someone else's patent. It's an important thing to think about that's in fact the way the Constitution is written. It says right to exclude. That's the common thing. I don't think innovation and creativity are at all different subjects. I think they're the same subject, and they only look different to us if we start thinking that one type of IP or two types of IP can cover the waterfront, and they don't, really. We've seen IP evolve. We saw MaskWorks come into being in the 80s, for instance, as a new form of IP. We see various ways to try to attack, so to speak, the protection of new ideas. We have this ongoing decades-long debate about business methods. We have the Alice case just recently. It wasn't really about software, it was more about business method, but I mean, the Supreme Court didn't even want to call it a software case in a way, well, depending on which opinion you read. And there were many opinions written in that case. So we're struggling with these different forms of innovation and creativity and trying to fit them into the old molds of protection, and it often just doesn't work. We have to be more creative ourselves in how we think about them. So we're actually, rather than see this as a tension between those subjects, I see it as an overall tension in the whole area of this kind of development. We haven't yet been clever enough to resolve how each type of innovation and creativity should be rewarded and convince each other of that. Unfortunately, legislation is not a very good vehicle for that, because this just in, legislation is about politics. And it's not usually about substantive debate. Of course, there's a lot of that in there, and there are people like myself who, that's the only game I know how to play. I don't know how to play the political game, nor do I think I want to. But it boils down to, go ask what company X thinks, because they're the biggest company in my state, and unless they back it, I can't agree with your position, which I otherwise agree with. And I got that kind of response a lot when we were working on the AIA. So we need to take the debate outside legislation and talk about it this is a very good format for this discussion among the academics and the practitioners, and come to some kind of understanding on how we solve these problems and how we accommodate the new forms of innovation and creativity.
And with that, of course, now I'm going to ask a question about legislation. A rather imperfect lead-in, Matt. And let's try to keep this to about 2 minutes each, so we have some time for questions from the audience. So if you could persuade policymakers, in other words, probably Congress, to make one or two positive changes to laws that affect creators and innovators, what would you choose? And here I'm going to also acknowledge something I didn't offer before, but perhaps the optimal real-world solution is, for God's sake, leave well enough alone. But I'd like to hear from each of you in a couple minutes what you might want to do.
So I guess I'll say something from my own personal perspective rather than taking a Copyright Alliance view here, just because we're in the midst of a big copyright review process. But I have personal views as a copyright lawyer who's worked in this area for a long time. And it's been really interesting going through the review process at the House Judiciary Committee, and I think they've done a remarkable job really thoroughly reviewing many of the important issues and challenges facing all of the copyright community, the creative community, the user community. And what I keep concluding as I look at all of this is that this all started with this call for the next great Copyright Act. And to me, I think maybe what we need to do is to take a step back and not look for a next great Copyright Act, but start looking at the health of the Copyright Office. Make sure that what we have in place is an entity that can actually administer the laws that are in place, and maybe even look at the office and look at building the office into something bigger and different than as it currently stands and as it currently exists. Because I think a lot of the challenges, if you look at what the House has looked at during the review process, many of those could be dealt with through regulation if we had an entity that could actually independently issue regs. And that might be a very good way to avoid continuing to complicate the Copyright Act with very difficult to understand for the layperson provisions of copyright law, or provisions that are very dense and complicated and very industry specific, that in other areas of the law I think are traditionally dealt with in regulatory bodies rather than through legislation. But we don't have to go the full way to creating an agency. I think there are steps in between. But I think if I had one thing to focus the Congress on, it would be you really need to look at the Copyright Office. They need to be healthy. They need to be up to the task of administering the Copyright Act. They need, appropriations up to the level that they can actually have an IT system that works, that they can be fully staffed to meet the needs of their users. But I'd like personally to see that thinking go more bold and go a step or two further. So, and I'll now duck and run if my members are disagreeing with me, and we'll see what happens.
Lori?
So, very similar answer. It's unfortunately on Capitol Hill, it's a politically unpopular and politically non-feasible answer, but making sure the PTO has the resources it needs to do an effective job on the front end. When we start talking about quality concerns and overly broad patent claims and, factors that potentially encourage litigation over, voluntary agreements, voluntary collaboration, a lot of that could be addressed if you had a highly functioning patent office with the appropriate resources, training, et cetera. Now, that begs the question, and I think it's an important question to raise, of is there really a quality crisis at the PTO? Is there, there's a lot of rhetoric surrounding the patent legislative debate that I take issue with, because the reality is when you look at what I would consider to be credible studies, credible data, we do see a PTO that's been much more focused on quality examination over the last several years. It's been laser focused on the whole software related patent issue, the business method area. We now have a post-grant system, much expanded post-grant system in the wake of the American Invents Act, which creates opportunities to challenge questionable patents through the PTO versus litigation. So a lot of the concerns, the so-called problems that have been cited as justification for new legislation, I do think we have to take a hard look at the data and test whether in fact those problems are real and the extent of those problems. But regardless, I do think full funding of the PTO and permanently ending fee diversion, those are long-standing goals that the patent stakeholder community has been advocating for years and years and years. We almost got a permanent end of fee diversion through the American Invents Act. We didn't at the end of the day because of the appropriators. And as I said, it may be a politically untenable goal, but I really do believe that should be the focus of improving the patent system, making sure that the patent office has the resources, the guidance, the tools, the leadership that it needs to function at full capacity. Beyond that, I would just say, Mark, I know that let's let the dust settle is an unpopular answer, but Phyllis is absolutely right. The AIA when it was signed into law, it was described as the most significant piece of patent legislation in 60 years. We typically don't have sweeping pieces of patent legislation every 3 years. This is a system that depends on stability, predictability, certainty. Putting aside the fact that we have this new legislative landscape, the courts have been incredibly activist in the patent area for a decade. Just trying to make sense of the 101 decisions that have come out of the Supreme Court in recent years is, again, it's created an incredible amount of uncertainty within the patent ecosystem. Allowing opportunity for those issues to settle, and I agree with the comments that have been made that Congress unfortunately acts with a blunt instrument, which is not necessarily driven by the appropriate goals. Allowing the courts, allowing our regulatory agency allowing our economy to kind of make sense of all of the change that's been taking place, I think is a far better course than trying to, fix all systemic problems with new legislation.
Thanks. Phyllis?
Well, I would say, taking a page out of the Hippocratic Oath, first, do no harm.
Yep.
Or I should say, do no more harm, to be more accurate. The minimum is to let the AIA work through its growing pains, which it is currently going through, particularly with regard to many of the new proceedings that have been implemented at the Patent Office. I mean, first of all, let me say that I totally agree with number one is patent quality. But since Lori's already asked for that, I'm going to ask for something different. If we want to do anything, let's think about reordering the incentives to incentivize folks to reach licensing agreements and to reach litigation settlements. So that would mean, for example, reining in the Seagate decision from years ago, incentivized licensing, and also overruling eBay, making it truly, as Matt mentioned, the right to exclude. If property is an exclusive right, let's make it the right to exclude.
Thanks.
I was going to say that. All very good comments, especially the ones about fee diversion and eBay. 101 has been a changing landscape for quite a few years. When I was in law school, Diamond versus Deere came down, and I was writing a paper on software patentability for my last year of law school, and when the decision came down, I had to not change directions, but I had to incorporate a lot of new information. That was 1983, and it's still going on. And I think the problem is, I will get specific, but I'll set the stage. I think the problem is not so much subject matter patentability as things like obviousness, and I think that was already said today. So some specific suggestions. Take care of the subject matter problem by accommodating the new forms of subject matter that we've been encountering. For instance, we should seriously consider in the United States passing utility model law, like they have in Germany, Japan, Taiwan, China, Denmark, for instance. And for those of you who aren't in the field, utility model is a way of protecting an article, not a process, but an article, something. And it can be the same thing that you're trying to get what they call an invention, the regular utility patent on. But you do it without a search. And you protect the thing, but only exactly that thing. And when you go to enforce your utility model patent, your utility model issuance, the defendant can then try to show that it was actually in the prior art. Effectively, it's a novelty discussion rather than an obviousness discussion. It's proven to be very popular and useful in other countries. This would solve some of the big problems we have. Time to issuance is a very big problem. Uncertainty of issuance. And in some industries, by the time you get your patent, the form of product that you're protecting is 2 generations old, and you're on to the next 2 things. So these things can issue very quickly. You have something to show, and if they should be challenged, they can be challenged much more simply and less expensively and quickly than a regular patent. So I think we should think about that, not just for things like this, but for semiconductors, for instance. Most utility model, or maybe all of them, laws around the world exclude they exclude processes. Some specifically exclude semiconductors, like in Denmark. But in Denmark, they have another form of protection just for semiconductors, which is actually pretty much like the utility model. And so what I'm driving at is we shouldn't think everything is a copyright or everything is a patent. We can invent new forms of IP. The Constitution doesn't prevent us from doing that. It doesn't have to be called a patent. And so we can come up with, we could come up with the equivalent of utility models for software. The problem with software is it has very short life, and it's harder and harder to get a patent issued. It's spreading farther and farther apart. And when your protection is available finally in patent form, if it's even worth going to court over, that takes another 7 to 10 years, especially with all the re-exams. So patents are just, they work obviously to some extent, or software developers and companies wouldn't be still applying for them, so they're important, but they have a lot of problems in the patent world. And in most of the world, software patents don't exist or are almost impossible to get. So we should be thinking about new forms of IP to cover the new forms of inventions that we've been coming up with. I have some other ideas.
All right.
Have I used my 2 minutes?
Yes. Let's leave some time for questions.
Let me just take 30 seconds and I'll wrap it up.
Okay.
I think we need to, everybody here has talked about patent quality. We need to greatly improve our search capabilities, and I think we need to talk about something like sort of an ISO 9000 for search, and internationally arrived at, because all the major patent offices would have to agree upon it. But something that says if you do these 10 things, you've got an A-grade search. I have some ideas on that. Enforcement's a huge problem. We should think about a voluntary pathway to enforcement that is non-jury, that is quick and less expensive. Now I say non-jury because that's the big problem with enforcement. It's what creates most of the delay and expense, or a lot of it. Discovery is a different matter. We aren't going to have a constitutional convention on jury trials, but we should think about that. So those are scratching the surface of some ideas.
All right, thanks. Questions? Let's see. Ron?
2 questions for Matt. I have more for others, but I'll start with Matt and see if we have time for others. Utility model that you mentioned. I saw that concept as essentially an anathema to the patent system. An anathema to the patent system because in many respects, it's sort of mutually exclusive with proper inventions of patents for the following reason. You see it in China, you see it in some Asian countries where utility models are taken out once a publication of an invention is made here. And we can't come to those countries because they surround us with all these 300 utility models of how to actually implement the concept in the invention patent. So it is essentially an undermining process for real invention patents, and it's actually counterproductive in that sense. And so, you know, we, in America, we don't have utility models, and I believe for a good reason. And so a lot of people who were offering that probably missed the fundamental function of the invention patent system. That's number one. Number 2, on the search, I agree with you, but like Lori, I think there's an over push on this issue. There's always, when you have 23 hours of examination time per application in the patent office, you're going to get that much certainty of ability to do it. And there's no statute that says how many hours or what error rate we should have. If Congress wants to deal with it, it needs to actually assign a numerical error rate. Everything else is platitudes.
So on the utility models and anathema, I see utility models mostly as a time-shifting mechanism. It shifts the search downstream, shifts the examination downstream. That has a big benefit because most patents are never enforced. So you've saved all that time and expense of both the...
You still have to search for good novelty, right?
Just novelty, but novelty is a lot easier than obviousness, and there's much less argument, yeah? So it just shifts everything down. It's much easier, it's much faster, and I'll make up a number. 98% of patents aren't enforced. I just made that up. I don't know what the number is. Does anyone know the number?
It's about 98%.
Okay.
Yeah.
And so all of those, you've just saved an enormous amount of time and money. So, and because when you do end up searching them, even beforehand, it's just a novelty search, not an obviousness search, you saved a lot of time and money, even for the ones that get.
Can I?
No, but
Let's,
I'm not
let's-
suggesting not, but
Can I-
not having patents
Let's
is
not have a utility model debate.
Can I just, but just to raise one issue with respect to having a special form of protection for software patent. I mean, there's a very significant definitional issue of what is a software patent.
Mhm.
And I don't know that we have a rational answer to that question. And it does concern me that this notion of software patent starts to sweep in a very broad range of patented technology, including truly technological inventions that once were implemented through hardware that today are implemented through software. So I just think we have to be a little bit careful
My
about
point was
how you
not
define the
to
term.
eliminate the ones that exist, because they obviously have utility, so to speak, but to think about, what will solve the problem of
Mhm.
the ones that can't be protected under current law.
Right. Got it.
That's what I'm saying. We should think about protecting innovation for which there is no good protection
Got
at the
it.
moment.
Got it. Okay.
That's what I was.
Kirti.
Regarding the search.
Can we take
oh.
Kirti's question?
Oh, I was going to answer his second question.
Oh.
Okay, go ahead.
Well, actually, it was related, so I'm continuing the discussion because we've heard this in your previous remarks and in the response that there's a perceived problem in some people's minds that only 1 or 2% of the patents are enforced, or there are many patents that are of average value and some patents have very high values. But what's wrong with that? It's always going to be like that. That's just the nature of innovation, of inventions. That you try many bets, and for some you miss the you hit a home run, and for others they're completely worthless. I mean, there are many researchers in the room. People know how research works. It's often like this. So just because we can cite such statistics, I'm not sure how that lends itself to debate or discussion about improving the quality of the patent system.
So I'd say that it's not a problem, it's an opportunity. I agree it's not a problem. The fact that there are 98% that are never enforced means we can look at those 98% and find a more efficient way to deal with them, because we know that statistically that number won't be enforced. That's a good thing.
I think one other possibility that we might consider is going to a requested examination process. That way, having time, because we have lots of, I was part of one of these companies, we filed a lot of patent applications around a lot of things, because if we don't know which direction we're going to go. The patent office will take those up for examination as they would do anything, but when it gets to be 18 months down the line, we've decided we're going in that direction, and that's the thing that's the most important, or we've decided these other things are worthless. And it could help the pendency problem. It could also provide more than the 23 hours for any given application in terms of searching, because now there's less in the pipeline. Just a thought.
We had a question over there.
For those of us who are perhaps less expert about patents, Phyllis, you mentioned something about increasing incentives for NPEs to get licenses. Could you maybe explain more about what those incentives could be?
Well, in particular, I think the one that's the most powerful is that well, let me sort of set the stage a little bit, and that is there have been a series over the past 10, 15, 20 years of court decisions that have basically, and legislation, I'll also say, that have basically tilted the playing field, I will say, toward the accused infringer in this way. Time. One way is time, and they have the advantage of time because they don't suffer any real potential downside risk other than having to pay money. One
Why
of the
is that
reasons.
because of a lack of availability of preliminary injunctions or something like that?
Yes,
Okay.
it is because the eBay decision basically made it impossible for a non-practicing entity or entity not practicing its patent, I would say, to get an injunction. And prior to that, in my view, the appropriate situation existed where the true exclusionary nature of a patent was manifested in the legal framework. So once you take away the possibility that the patent owner could prevent the infringer from practicing the patent, once you take that away, then there isn't a strong incentive for the infringer, particularly if they're well-funded, right, to come to the negotiation table, because they can buy a lot of litigation and they can put the day of reckoning way off. And in nowadays, I mean, just the reality of it is that the cycle of particularly general counsels and companies, you know, why would I settle with this company? It will be the next guy's problem or the next woman's problem. So that's what I mean. I think that's probably the starkest example of a place where the incentive for the potential infringer or the accused infringer to come to the table is no longer there in a real way.
Thank you.
Thanks. I think we have time for one more.
Just to follow up on the discussion around incentives, One Plus here, Hamilton speaking. On the copyright side, it seems like you have a carrot and stick parallel system where you can get civil. On the copyright side, it seems to have a parallel system where you can get either civil or criminal liability. Would it make sense to adopt something similar on the patent side, where you also have perhaps the chance of going after a accused infringer criminally?
I think the problem is intent, because copyright requires copying, and patent infringement can be completely innocent. So I think that's a big problem. Scienter.
Well, I mean, they're both strict liability offenses, except in this, but yeah, I think it's a far more complicated issue of whether, in fact, you're infringing a patent than it is a copyright. We also haven't seen, to my knowledge, the kind of the sort of a true black market emerging in patent infringement. You know, in the same way that you see this kind of criminal organized element around piracy. But I think just the complexity of issues of patent validity and patent infringement make criminal liability a much more problematic option.
You might be able to argue that there should be criminal liability for continued infringement, but that's a different question right now. eBay makes that more difficult.
With that, I think our time is up, and so let's thank our panelists.